Coming up next on Arizona Horizon, it's our annual U.S. Supreme Court preview show. We'll look at some of the bigger cases the High Court is expected to consider, including questions on presidential authority and congressional redistricting. A U.S. Supreme Court preview next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of Arizona PBS, members of your public television station.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. The U.S. Supreme Court begins a new session next week with a number of high-profile cases on the docket. Among those cases, challenges to presidential authority, along with cases involving conversion therapy and congressional redistricting. Joining us now is ASU law professor Paul Bender and attorney Stephen Montoya, a partner at Montoya, Lucero and Pastor. Good to have you both here. Thank you so much for joining us, Paul. Good to have you here as well, Miss. Let's start with you. And let's start with the state of the Supreme Court. What are you seeing right now?
Very little. I think we're waiting. The court has no direction right now and has no really outstanding membership. It's quite a disappointing institution now, and we're waiting to see what's really happening. The court could stay the way it is for several years. There's nobody really old there. I don't know exactly how to say this. There seems to be almost no leadership on the court. Nobody is going anywhere. They're all doing their individual thing. There's nothing wrong with that. But there ought to be some people on the court who other people listen to, sometimes at least, who give some direction. There just doesn't seem to be anything like that.
Stephen, what do you think? No direction on the court right now?
I think there is direction in the court, and it is the wrong direction, and it is direction backward. The court is taking the country backward to a history that no longer exists and that the people no longer want. I think the court is going against the grain. The leadership on the court is out of touch with reality, out of touch with legal history. It purports to be an originalist court. However, its knowledge of history is wrong and paper thin, and it has no basis in history. And to the contrary, it's anti-historical. The court has empowered the presidency in a manner that the founders would have found repugnant. One of the purposes of the Constitution, as all conservatives know, is to limit government. And the court is not limiting government. It's empowering the executive in a way that the Constitution was designed to prevent.
Paul, before we get to some cases, you and Stephen both talking about the direction and the lack of leadership and what's going on with the court. How did it get this way?
That's a good question. Because of the membership, there's really nobody on the court now who, it ought to be the Chief Justice. That's a big disappointment to me. He is, I think, completely failed as a leader on the court. He joins most cases. He says things, very few other people agree with him. He doesn't seem to be setting any direction. And worse than that, the whole ethical situation on the court is something that somebody needs to take a look at, and nobody's taking a look at it. So you have these 9 people, each going their individual ways. The 3 liberals do communicate with each other, and I think it's not fair to brand them with everything that I'm saying. But the rest of the court, I just don't see any coherence there.
So, Stephen, is this not now, or not now, has it ever been a Roberts court?
I think there was an inkling of a Roberts court, but with the ascendancy of President Trump and his 3 nominees, Roberts was losing the leadership of the court. And what he decided to do in order to try to maintain his leadership was to shift to the right. And that's what he's done. And now we have a right-leaning court, but when I say a right-leaning court, it's not a conservative court. A conservative court would oppose absolute government, would oppose the militarization of police forces, and would oppose virtually everything that this court has rubber stamped that the Trump administration has served them. And it's not a partisan thing. True conservatives, for example, Mitch McConnell, believed in limited government. The Republican Party and the Constitution stands for limited government. That is not what the Supreme Court is serving us.
Paul, before we get to cases here, Stephen doesn't see a partisan divide, but I think in many cases there is a partisan divide. Is that going to ease? Is that going to harden? What are we going to see this term?
It seems to me it just keeps hardening. The only thing that would make it ease would be new people on the court, and they can be. But the most recent new people replace other people who they thought alike with, or something like that. And so there's, almost always there's somebody on the court who other people listen to, and it's not really leadership, it's intellectual coherence, talking to each other, going in some direction, having some future. I just don't see any of that on the court now, except with the three liberals who often don't get together, but they often do. And when they do, they present something. But there's only three of them, and there's not very far that they can go. So my general opinion is that it's a really undistinguished court.
Stephen, let's get to the cases here, and let's start with presidential authority. Trump v. Slaughter is the case. What's it all about, and how does it deal with presidential authority?
Well, it threatens to greatly expand presidential authority. Ms. Slaughter was a member of the Federal Trade Commission that was established in the early part of the 20th century to protect competition and consumers. And in 1935, the Supreme Court of the United States decided a famous case, Humphreys Executor versus the United States. President Roosevelt was trying to sweep the government of the old conservatives that were thwarting the New Deal, and Humphreys was one of them. So President Roosevelt fired Humphreys. Humphreys fought it in court, died during the fight, and that's why it's Humphreys Executor, the executors of his estate. And the United States Supreme Court unanimously ruled in 1935 that the president did not have the power to remove this individual of this independent agency, and they could only be removed for cause, which meant misconduct or negligence. And that established the independence of these federal agencies that are supposed to be non-political, because not everything in the United States can be non-political. And Slaughter threatens to overrule that regime to allow the executive to fire all members of these independent agencies.
Paul, what do you make of the case?
I agree with everything Steve just said. It fits in with the rest of what's going on the court, which is they seem to be ceding power to the executive. I know that you can believe in a strong executive, but if you just give up entirely enforcing the Constitution against the executive and assume that anything the president wants is fine, that's not what they're supposed to do. And there's no real interplay between them. They don't talk to each other, the president and the court. And so I just see this court's deciding cases not as well as I would like them to, but that's more or less okay. It's their lack of direction, the lack of going anywhere. It's just a bunch of cases which don't really relate to each other. Now, maybe that's a good thing, because if they didn't have a direction, it'd probably be one I didn't like. But the court should be strong. The court is not only decides cases, it sets a tone for the whole judiciary, and it sets a direction for the development of the law. this court is not doing that at all.
So what are your thoughts, Paul? How do you think this is going to be decided?
It's not going to be decided. I mean, that's the thing. They're there, and they're there for the rest of their lives. Some people think that the size of the court should be enlarged. I'm against that. I'm not quite sure why. Maybe it's just because I'm used to it the way it is. But I don't think it is going to get enlarged.
Yeah. Stephen, as far as this case is concerned, though, what do you think the court's going to do?
I think the court is going to allow the president to get rid of Ms. Slaughter. However, I don't think that it's going to extend that rule to the members of the Federal Reserve Bank. However, this is ahistorical, because if you look at what the framers did, they established two independent bodies: the Sinking Fund Commission. The president couldn't fire everyone. The First Bank of the United States. The president couldn't fire anyone. George Washington, Ben Franklin, Alexander Hamilton, John Adams, Thomas Jefferson, they were all involved in those. The framers do not support the unitary executive theory.
And with that in mind, Paul, real quickly, compare this case with the one involving the fired Fed governor. I mean, are we talking the same things here, same basic principles?
Say that again.
The fired governor of the Federal Reserve Board, this the same principles involved here?
I think so. Some people say the Federal Reserve Board has more independence than other agencies. I'm not quite sure why. I just don't know that area of the law very much.
Yeah, okay, all right. Stephen, the next one is Learning Resources, Inc. v. Trump, and Trump v. VOS selection. Basically, what we're talking about are tariffs here.
Yeah. Under the Constitution, Article 1 of the Constitution, the longest article of the Constitution, only Congress has the power to tax. In 1977, Congress passed an act, the Emergency Economic Protection Act, the International Emergency Economic Protection Act, and it actually says that the president, in times of emergency, has the power to regulate imports. It has never, in its 50-year history, has been interpreted to authorize the president to impose tariffs unilaterally, even in case of emergencies. But in this case, the president is imposing tariffs, even though he doesn't have the power. Only Congress has the power to tax. Moreover, there is no emergency. What is an emergency is something extraordinary. He is imposing tariffs across the board on large countries, for example, the Soviet Union, and small countries, for example, Guatemala. Across the board, he has taken the power to himself to tax. I think it's against the law.
Yeah, Paul, the president says he sees an economic emergency here. It's time he has to move on this.
But the court just sits there. What I'm trying to say is the court is not playing the part it's supposed to play. The president is doing things that are very strange, to say the least. They're certainly very controversial. The court just sits there and lets them happen, one after another. And if they let that keep happening, he's really changing the form of the democracy. Now, of course, he's only in there for a few more years, one hopes. And but you don't know what's going to happen after that. Where is the country going to be when he leaves the presidency?
But Paul, when the president says that trade deficits threaten the national security and thus there is an emergency and it's within his powers to go ahead and issue tariffs, does he have a point there? Does he have a legal point?
No, I don't think so. The courts let him do that. I think that's been wrong. He doesn't have the power to set tariffs. Well, how does that fit into the general scheme of the Constitution? I mean, that's a legislative job. The legislature, the Congress does not seem to be standing up for itself. Again, maybe it's better than if they stood up for themselves, because they wouldn't stand up in the right direction. But they really should play a much more of a role in the governance of the country than they're doing.
So again, I guess I asked the question, the international emergency economics powers, if it doesn't allow him to move in what he considers an economic emergency, what good is the act? What do we
Well,
do?
I'll tell you. I'll give you two examples. When it was used appropriately, there were emergencies. During the Iranian hostage, when they overran our embassy and took everyone working inside the embassy as hostages, President Carter imposed sanctions. That was the first use of the statute. That was an emergency. They've attacked the United States abroad. They've held our people hostages. Of course, we had to impose economic sanctions. Another time they used it was when Russia invaded Ukraine. That was an emergency. That was a true emergency. Guatemala, imposing tariffs on Guatemala is not an emergency. He has imposed tariffs on every country in the United States, and a lot of them don't really trade with the United States, don't threaten the United States in any way. He has taken the power to tax unto himself, and it is really hurting our country internally. But he's also he's collected billions and billions of dollars that if the court rules against him, we're going to have to pay back, which is also going to be catastrophic economically. This president has really is leading us right off an economic cliff.
And Paul, how do you think the court's going to respond to this? How do you think the court's going to rule on this?
Well, so far they've done very little, really nothing, to maintain their power. And I don't see that's going to change with the current membership. And I don't know who's going to leave first and how many of them there'll be, but that's a long way off, I think.
Yeah.
And there's normally with the court being as stable as it's been over the last 20 to 30 years, some leadership would develop. There would be somebody who, when he or she wrote something, other people would pay attention and react to it. And there would be some intellectual activity going on among the members of the court. I don't feel that now at all. I just feel it 9 people doing what they're doing. And again, I have to say, maybe it's better that they don't get together because they'd probably get together and do things I wouldn't like. But they're really not fulfilling their role. They're a separate, independent, and very powerful branch of government. And they're just not acting that way.
Stephen, case Childs v. Salazar. This one deals with conversion therapy. A case in Colorado.
Yeah, case out of the 10th Circuit. Mental health professionals are prohibited under a Colorado state statute from trying to convert gay or trans children into straight children, and a counselor has said that violates her rights under the First Amendment and violates her rights under under freedom of religion. The 10th Circuit said, no, it doesn't, because this is not free. We're regulating professional speech. The government can prohibit psychiatrists and other mental health professionals from using electroshock therapy like they used to use in the 60s, from using leeches to exercise germs from your bloodstream. In the Middle Ages, exorcism was used to actually try to heal people from disease. The government can prohibit all those things in the field of mental health or physical health. Now, if people want to practice that outside of their profession, they're free to. So I don't think she has a strong case. The Supreme Court has accepted cert, which suggests they disagree. I think that's a bad idea. It's another one of this Supreme Court's attacks on discrete and insular minorities. That is a trend. I'll shut up in just a second. The primary purpose of the 14th Amendment was to prohibit caste legislation. The Supreme Court is empowering caste legislation and creating lower classes of people who don't have the same rights that everyone else has. And that's against the 14th Amendment.
Paul, the idea of regulating, the state regulating professional speech and speech rights seems to be at play, or is it at play here? What is at play here?
What are you referring to when you say that, Ted? In what way is the court doing what you just said it's doing?
In terms of looking at this case, they're looking at a counselor, a religious therapist who said her free speech rights were violated because she's not allowed by law to conduct conversion therapy.
Yeah, I just don't understand how that's free speech. It's a right to practice her profession the way she wants to. She has that right, I think. It's not as strong as a speech right. But again, the court is just, they're just not coherent to me. Want to go directly to what the problem is, regulating a profession. It has nothing really to do with free speech.
It's like a lawyer.
Kind of independent.
Lawyers can't counsel their clients, oh, you don't have to obey the law. You know, the president wasn't duly elected. He doesn't deserve respect. You don't have to obey that law. You're a sovereign entity unto yourself. You don't have to obey the law. Lawyers cannot give that type of advice. Non-lawyers can, but lawyers cannot. It's a matter of professionalism.
It sounds like, from what I've seen, the Supreme Court's turned down similar cases in other states along these lines.
It has, however, it's accepted this case, which is cause to worry.
Yeah. All right, Paul, we got a redistricting situation here. Louisiana v. Calais, I guess. It's Louisiana. It's a new congressional map, and they're basically saying that it's racial gerrymandering here. How far does the court go into these kinds of things?
That's a good question, because I don't think that they have a coherent way of doing it. I think it has, what they do has to do with what they think about what the state government is doing rather than any principle. They've never really formulated the principles, constitutional principles, that balance the states and the federal government. They do them on an individualized basis, and I don't think you can tell what's going on. And so power keeps going back and forth. Nobody knows who really has it. All I keep saying, I'm just repeating myself, I don't think the court's doing its job. And it's really disappointing because on paper, they're quite a qualified bunch. And you would have expected that when they got together on the court, they would talk to each other, they would develop some theories, some directions. Some would be wrong, some would be right, but there'd be some intellectual activity there and some force there. What you have is 9 people who seem to be deciding everything all by themselves and no feeling that anything's going on. Maybe things don't need to go anywhere now, but I think they probably do. There's a lot that isn't right with the way the country's being run, and the court is doing nothing about it.
Stephen, this redistricting case, what do you see here?
Well, I think it's a really bad sign. This case was before the court once before because the lower courts had concluded that there was a racial gerrymander that diminished, diluted the voting power of African Americans in the state of Louisiana. The court consequently issued an order saying that the district lines had to be redrawn. And when they were redrawn in a very weird way, like in the form of a cigar over the northern part of the state. And the reason why they drew the lines that way was because they wanted to protect the voting districts of 2 very senior, important Republican members of Congress. So it had nothing to do with the weird cigar-shaped district that ran through the state horizontally, had nothing to do with race. But the need to redistrict had something to do with race because they had diluted African American voting. So what the district court did was they said, hey, African Americans make up 1/3 of the state. We're going to give them 2 districts out of 6. And the court didn't like that, so the court has allowed re-argument, and what the court is suggesting that it's going to do is say that all districting must be colorblind, and be designed regardless of race. And I'm all for that, but the problem is that district hasn't been colorblind in the past, and African Americans have been disfranchised. Moreover, there are big voting blocks of African Americans that live in the same communities. So voting districts are supposed to represent one community, and they've diluted it by making the districts like so far and wide that there is no African American majority when there should be. So I agree with Paul. It is an incoherent mess, and but they're doing it intentionally to destroy, ironically, the Voting Rights Act, which is authorized by the second section of the 15th Amendment.
All right, gentlemen, we got less than a minute here, so you got to make it quick here. And Paul, I'm just going to ask you, how consequential is this term going to be? I think Paul's feed, there he is. Can you hear me, Paul?
For a while there, I was blanked out, but I can now.
How consequential is this term going to be, Paul?
That's a good question, because there are a lot of potentially very important cases, but you can never tell beforehand whether they're going to really be important when you decide them, because they can decide a case in a very important way or a very narrow way. And it's hard to predict with this court what they're going to do, again, because it doesn't seem to be anything going on there in any direction. So
Yep.
Where's the leadership?
Yeah.
Do they
Yeah.
even talk to each other? I mean, there's supposed to be a collaborative body. It's supposed to get together and think about these things. There are a lot of problems the country has that the court just ignores.
Okay, and Paul, we're not ignoring you, but we got to stop because we're running out of time. And it's good to see you, and thank you for joining us, Steve. Thank you for joining us as well.
You,
We
sir.
appreciate it. That's
It's
it
a
for
pleasure.
now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.